chapter is Chapter 8, the court system, preparing for and testifying in court. Before testifying in court, law enforcement officers should have a working knowledge of the rules of evidence, understand the rules of admissibility, understand his or her role in the courtroom, which is usually as a witness for the prosecution, and understand the functions of all other parties in the legal process. There are many participants in courtroom dramas. They include the grand jury, the judge, the bailiff, the jury, the attorneys, the witnesses, and the defendant or defendants. The process begins with a grand jury. The grand jury convenes before a trial to determine whether there is enough evidence to hold a trial. The judge is the trier of law. The bailiff is the deputy in charge of the courtroom. The jury is the trier of fact. A jury is made up of members of the citizenry who are deemed to be peers of the defendant or defendants. There are attorneys, prosecution attorneys, plaintiff attorneys, and defense attorneys. The prosecution attorneys represent the state in criminal trials. The plaintiff attorneys represent the parties seeking remedy for some kind of harmful action in a civil trial. And the defense attorneys represent the accused. There are also different types of witnesses. There may be eyewitnesses, law enforcement officers, or expert witnesses. The defendant is the person or persons accused of wrongdoing. Both criminal and civil trials hear and see evidence to establish case facts. Juries and/or judges in some cases then decide whether or not those facts support the charges or complaints. The burden of proof in criminal cases is that the prosecution must prove that the defendants are guilty beyond a reasonable doubt. The burden of proof in civil cases is that the plaintiff must prove the defendant's guilt based on a preponderance of the evidence. Attorneys for all parties attempt to gain a strategic advantage by gathering as much information as possible. The information gathering process includes depositions, which are sworn testimony given by witnesses in pretrial preparation, and discovery, which is the pretrial information gathering procedure involving interrogatories, motions to produce or suppress, and meetings with investigators and expert witnesses. Perjury is the lying under oath and is punishable by fine and imprisonment. The trial process begins with jury selection. Once completed, there are opening statements by both sides. The opening statements outline how each side's case will proceed. After these opening remarks, the attorneys call witnesses to the stand and the trial is underway. The process for examining witnesses involves direct examination, cross-examination, redirect examination, and recross-examination. For example, when the prosecution questions witnesses called to testify on behalf of the state, this procedure is referred to as direct examination. Following questioning by the prosecutor, defense attorneys have an opportunity to ask further questions of prosecution witnesses or to clarify answers to their previous responses. This procedure is referred to as cross-examination since the witnesses were called on behalf of the prosecution. In the event the defense manages to raise an issue during cross-examination that may require further clarification, the prosecution has an opportunity to conduct a redirect examination after the defense attorney is finished. Likewise, the defense may conduct re-cross-examination following any redirect examination of the prosecution. The judge serves as a final arbitrator with respect to ending the questioning of a witness. After all witnesses are called, closing arguments are presented. Closing arguments summarize the case and call for a verdict for each client or the state. Finally, the jury is given their instructions by the judge, and they deliberate until a verdict is reached and announced. As a law enforcement professional, you will probably be called to testify at a trial at some point in your career. Nonverbal communication is important for your credibility when testifying. You should have appropriate dress, wear your uniform, or appropriate conservative civilian attire. Your paralanguage should be clear and confident. Your body language should be appropriate. Remember that body language enhances your credibility as a witness. When testifying, law enforcement officers should review field notes and reports prior to testifying, realize that notes and reports may be examined by the defense attorney or attorneys, meet with the prosecution attorney or attorneys before trial, and listen to the question before answering. You should also answer only those questions that are asked. Also, do not be afraid to say, "I do not know." And finally, do not argue with the attorneys or lose your temper. When testifying, corrections officers should remember why you are in court. Assume the jury is skeptical of you. Be prepared. Know your professional scope. Be concise, clear, complete, and correct. Speak to the jury. And make sure to refresh your presentation skills. When testifying, private security officers should be prepared and act professionally. This means you should be on time, state the facts, don't show feelings or emotions, don't answer more than necessary, pause before answering, and don't testify for another officer. For your final assignment, you will be watching and analyzing the video of a criminal mock trial. For this mock trial critique assignment, you will need to discuss the presiding judge, the selected prosecution attorney, the selected defense attorney, the selected prosecution witness, and the selected defense witness. There are 3 attorneys and 3 witnesses for each side, so you will need to select only one for the prosecution and one for the defense. When writing up your analysis, make sure you have an introduction and a conclusion. You will also need well-organized body paragraphs. Include previews, summaries, and transitions within your writing. Make sure your word choice, sentence structure, grammar, mechanics are correct. Again, make sure to use correct APA style referencing. Remember, if you have any questions, please contact me. I look forward to reading your critique of this criminal mock trial.